why Raghav Chaddha's movement to BJP might be counted as defection.
We, the 2/3 members of parliament belonging to the Aam Aadmi Party in Rajya Sabha, exercise the provisions of the Constitution of India and merge ourselves with the BJP.
Does he have any exception to the provision given in the 10th schedule, and what does anti-defection law in the 10th schedule provide to the MPs which want to move from one political party to another? Anti-defection law was brought in to address the situation of Ayaram Gayaram. But in this very scenario, when in modern politics in 2026, we see yet another bunch of MPs moving from one political party to another, does anti-defection law protect that? Does anti-defection cover that? And most importantly, what are the provisions around it which make it right or make it invalid? Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to understand the exodus of AAP Rajya Sabha MPs to BJP. How right is this? What does Supreme Court say on that? And most importantly, what are the provisions of anti-defection law? So let us start from scratch, understanding that what exactly has happened. So as of now, 6 Rajya Sabha MPs plus Raghav Chaddha, who all belong to Aam Aadmi Party, they have decided to join BJP. That means leave Aam Aadmi Party and join BJP. Now, this is the layman understanding, but what actually they have done is they have announced a merger. These 6+1 MPs have announced merger with Bharatiya Janata Party. And now what they are saying because 2/3 of the MPs in Rajya Sabha of Aam Aadmi Party approved this merger, that is why it will not be counted in defection. So this is the story that has been put forth, but so there is an immediate constitutional question that pops up, is the fact that if this act has been carried out, is this a valid merger or this should lead to disqualification? Because this decision and what has happened has huge political significance given in the very current environment where we are seeing occurrence of assembly elections across the state and upcoming Punjab elections as well. And furthermore, it raises concerns about party fragmentation, how we have to look at strategic defections, and most importantly, the institutional integrity which is present of parliamentary democracy. Now, to understand this better, that what is the answer of the constitutional question that I just mentioned, we will move to understand that what is present in anti-defection law, what are the exception it gives, and then maybe we can understand better the claim that is being made by these 7 MPs. So, when we look at anti-defection law, which is in 10th schedule of our constitution, it was adopted by the 52nd constitutional amendment which came in 1985. Now the anti-defection law, the whole purpose was to prevent the moving of already elected legislators, be it in assembly elections, be it in Lok Sabha election, be it in Rajya Sabha, these elected legislators to switch parties or vote against their party directions. Now these directions are given by whip, which are present in parliament. Who are whip? Let me know in the comment section. I'll be explaining this in a while. Now when we are talking about this whole idea, that is what was Ayaram Gayaram syndrome, that as soon as they win elections, legislators used to change the party. Now anti-defection law was brought in and grounds for disqualification were set. What were the grounds for disqualification? The first direct ground for disqualification was that you have voluntarily given up the party membership. If a particular legislator says that I don't belong to this particular party on whose ticket I have won the election, that means he is having the ground for disqualification, he will be disqualified. Second ground comes in the scenario then where we see voting happening contrary to the party direction. If party has said, political party has said that you have to vote for this particular motive in this way, but that legislator does not agree to that. So if they are not following, even abstaining from the vote will be counted as violation, and this violation is present against the whip, because whip is responsible for the parliamentary discourse that is carried out for the party across voting and everything. Now, a whip in parliament is basically a written directive that has been given by the political party, which needs to be followed for the vote on a particular legislation that is coming up. Now, in this context, this holds a lot of importance. That person not only belongs to that political party, but also at the same time, he is supposed to follow the lines set up or the ideology set up by that political party. And then comes the third ground for disqualification, that is when a nominated member, a person who has not been elected but who has been nominated. Can you tell me how many persons are nominated in a Rajya Sabha? So, if the nominated member joins a political party just after 6 months of taking the seat on the house, if they do so before, it is okay, but after 6 months of taking the seat in the house, then it is grounds for disqualification. But at the same time, when this law was laid, exceptions was also put forth so as to ensure that when we are talking about addressing the problem, there are certain times genuine concerns, so they should also be addressed. So, in this context, certain exceptions were given, and the exceptions were laid out in a form that there will be no disqualification in two scenarios. First, if there is a merger, that means at least 2/3 of the political parties, the legislators which are present in the house, they decide to merge with another political party. And the second exception was if a legislator becomes a speaker or chairman, and that is when they decide ki, okay, we are going to voluntarily give up our party membership because this house are known for neutrality and they do it voluntarily. That will not be a ground for disqualification. Now, this is the main part that is going to be our center of discussion for today. Now, before we move to understand more about this, let us also understand who decides disqualification. The disqualification is raised by a petition which can be filed by any member. This goes to speaker or chairman, and they have the final authority to decide on this if the legislator will be disqualified or not. But based on Kiloto Holhan case of 1992, we have a very clear judgment that judicial review is allowed of the final decision that has been made. So, the decision is final, but it is subject to judicial review. Now, this is the whole process, and as I said, our center of discussion is going to be the exception that has been given, that 2/3 of party legislature in the house agree to join another party. Now, what is the problem if the provision is already given? The problem comes into the picture with the key concept where there are two terminologies being used. The first one is original political party, second is legislative party. Now, when I am talking about the exception, that exception is given in the part 4 of the 10th schedule, that a legislator is protected from disqualification. These are the exact wordings. If the original political party merges with another political party, and second says at least 2/3 of legislators agree to such a merger. Now, based on that, when we look at the conceptual distinction, when we are talking about political party, we are basically referring BJP, AAP, Congress, right? And if we go by this definition for both of them, then the agreement of 2/3 of the members of the whole political party is required. And because AAP has not made any such announcement, no such agreement, this becomes grounds for disqualification. But if we go by the other term which we are focusing on, that is legislators or legislative party, that refers to only the member of parliament or member of legislative assembly of that given party. So, the number of MPs of AAP or the number of MPs of BJP will be counted in legislative party. So in this context, now that demand is being met, then this cannot be called defection and there are no grounds for disqualification. Rather, the grounds are for the exception which gives protection to the movement of these legislators. But when we look at the conceptual distinction, we also have to look at that what will be interpreted out of this. If we look into this whole situation, we need to understand that which particular term will be picked up from here. On that basis, it will be decided if it is defection or it will be an exception where it is protected by law. Because if we go to judiciary's end where there have been judgments about it, we need to look into multiple cases. For example, Subhash Desai versus Principal Secretary, Governor of Maharashtra. This is a very recent case of 2023 where we get to understand Supreme Court's position. What Supreme Court said in this particular matter, that legislative party, that means legislators which are present, they cannot decide apart from political party. They are not separate from political party or at least independent. And Supreme Court also said that it is going to be the political party which will have the primary authority. Furthermore, they recognized legislative autonomy, but they said that if we focus only on this, that means we are going to undermine what is present in anti-defection law and this is going to distort representative democracy. Now, if you go by this very case, then I think we have established that this would be counted as defection. But let me present to you another judicial discourse where we see Bombay High Court, when there was Goa MLAs case, they were the one to hold that if legislative majority is present, 2/3, then this is valid and we need to read paragraph 4 disjunctively. We can't read it. The approach should be literal, it should be more practical. But the problem here is this is where the defection that we are talking about falls under exception and there are no grounds for disqualification. Now the problem here is both of these jurisprudence, they are conflicting in nature, they are standing absolutely on the other side and that's why no clarity remains as of now. Furthermore, the only clarity we can expect is from Supreme Court in coming time because this issue is already pending in front of Supreme Court. So hopefully an answer to this will bring a clarification that if this exodus was defection or not. And when we are looking to the final answer to this, we also need to understand that this is a time where we clearly get to see that what is the scope of anti-defection law. Please understand, when we are talking about anti-defection law, this is not something that can become obsolete. Just like Constitution is a very living document, this also needs to be dynamic, change with the needs of the time. This is where we need to understand that what is the meaning of political party and what are the limits, if there are any, to legislative autonomy. This is where we will get answers on that. However, governance concerns remain because the merger provision gives a loophole, it might be misused. There is an encouragement of mass defection. Okay, basically anti-defection law seems like as of now that it is okay if you are moving in bulk, but if you are moving individually, it is not allowed. And this also weakens the party-based democracy, which especially India is heavily reliant on. If you look at individualistic democracy, in recent times we might have certain figuratives, but they are very bounded towards a certain party. So in our country, this makes a lot of sense and has a lot of significance. What are your thoughts on this? Let me know. Do you think this is defection or not? And most importantly, what should be the way forward? This is where the challenges needs to be addressed. So let me know that in the comment section. I'll be leaving you here with a prelims practice question, very important question from the perspective of schedules. Let me know the answer in the comment section. That was all from my side. Thank you so much.